focus on our Baird Trust services. So with Baird Trust soon to be a solution and available to you as clients in September, Mark McLennon and Mark Criner will highlight key trust solutions that may benefit your unique financial situation. They're going to focus on the benefits of establishing a trust, common uses of a trust, estate planning concepts and tools, and the relationship of our Baird partners. For those of you unfamiliar with Mark McLennon and Mark Criner, they're both trust strategists for Baird Trust, with Mark McLennon serving in our Milwaukee, Wisconsin location and Mark Criner serving in our Scottsdale, Arizona location. They both have over 20 years of industry experience and primarily work with Baird financial advisors and clients offering complex trust and estate planning guidance. So before I turn the call over to them, I do have a few housekeeping items that I'd like to highlight. For optimal viewing, we would suggest setting your layout to the side-by-side view via the circle in the upper right-hand corner of your screen. All participants are in a listen-only mode, but we would love to hear from you, so we will host a Q&A session at the end of today's presentation to address as many questions as time permits. You can submit a question by clicking on the Q&A icon on the bottom right-hand side of your screen. Just please be sure that you're addressing your questions to all panelists. This presentation is being recorded and will be made available along with the slide deck about a week following the call, and you can get this through your Baird financial advisor or via bairdwealth.com. Again, thank you guys so much for joining. Mark Criner, Mark McLennon, thank you for being here. I will now turn the call over to you.
Thank you, Justine. This is Mark McLennon. I'll get started. And I'm a trust strategist, as mentioned, and I'm in Milwaukee, Wisconsin. I'm joined by Mark Criner, who's going to cover the second half of this presentation. And I'm really going to start out by talking about just kind of estate planning in general, which includes not only trust, but also the probate process, because part of that discussion early on is just to set up, what are some of the benefits of a trust, which is what I will then get into, and have a little bit of a, what I'd call maybe Trust 101 session, just to discuss essentially how trusts work, some, as I mentioned before, some of those benefits, et cetera. Then Mark's going to talk about some specific situations, business succession planning, IRA planning, digital assets, things where specific uses of trust may make some sense. So to get started, assuming all is working, I did want to dispel a couple of myths kind of right at the beginning. And one is that you have to be dead or dying to need a trust. I mean, picture someone with a 4-poster bed with an attorney with a powdered wig sitting next to them with a quill pen, writing down their wishes into a trust so that they can have this last for future generations. This is not something that's just for someone in that situation. In fact, that's probably the worst time to be doing this kind of planning, if you could actually call that planning. So that's one myth, is that you have to be, dead or dying to need a trust. The other is that you have to have a lot of money to create a trust. You don't have to be a Vanderbilt or a Musk even to need a trust and see the benefits of a trust, because a trust is basically a fictitious person that you create that acts for you when you can't. So whether you're incapacitated or unfortunately, when you pass, you're no longer able to manage your affairs. And a trust essentially is that person that you've created. It's essentially a instruction book for how you would like your managed or your assets to be managed, how you'd like your beneficiaries to be treated, etc. So it is something, similar to an estate plan. It's something that everyone essentially should have, not just those who potentially see they might have some kind of estate tax issue. Because an estate plan, similar to a trust, is there to tell others how you want your affairs to be managed when you no longer can. It's a little bit more than a mass when you add a trust in, because a trust is actually providing a narrative with some specific instructions that, depending upon how the trust is designed, this might be something that's really meant to last potentially for generations. But again, when I say lasting for generations, that's kind of implying, well, you only need a trust if you've got a lot of money and you want to benefit people for years. Well, actually, that's not true either for an estate plan or for a trust. So we'll start out with, well, who really needs an estate plan? And the answer I typically give is you, everybody. Everyone should have some form of estate plan, because estate planning includes not only where your assets go, but it also includes, your own personal care. So things such as how you'd like to be treated medically if you're unable to make your own judgment, because if you need medical care, it's very likely that you're not able to make those calls. So it's not just for the wealthy. It's something where it can control what happens to you if you and when you die or become incapacitated. And it really tells your family, this is what I would like to happen. And again, very important to have that created while you have, a clear vision of what you want to do and while you have the capacity to make those choices and reduce it to writing. Because really what an estate plan is designed to do is preserve assets, to protect your loved ones, to pass things on, and to do it in a way that's really consistent with your own values. So in general, I think everyone needs an estate plan, but there's some specific situations where if I haven't convinced you yet, if you have minor children, for example, you can name the guardian for those children within your will. If you don't have a will, you don't have a trust, and you and your spouse perhaps die, and there's no one specifically there to take care of your kids, the guardian is usually named in the will, or there might be a trustee who's named not to essentially take care of the children, but to take care of the assets. So if you have minor children, very important to do some estate planning. If you care about privacy, particularly financial privacy, a trust is one way that you can keep things from public record, which when you go through the probate process, which we'll talk about in a minute or so here, that's something that becomes public record. If you own a business, there should be a plan for how should that business be handled if something were to happen to you. That should be very well tied in with your estate plan overall. If you're not comfortable with financial matters, or your spouse is not comfortable with financial matters, setting up an estate plan so you know who will be able to step in and help that spouse or you, depending upon who goes first, with some of those financial decisions is going to be part of an estate plan. If you own property in more than one state, each state has an interest in property that's held within its own boundaries, particularly real property. So having an estate plan can save your heirs a lot of trouble. You can avoid something that's known as ancillary probate, where just because you owned a piece of property in another state, someone may have to go to court to get that property transferred. Again, with an estate plan, there might be a few simple things you can do to avoid that process overall. And then lastly, and I put this lastly because a lot of people think of it first, well, I need an estate plan if I have lots of money and want to make sure that the estate taxes is properly handled or minimized, or I take advantage of those exemptions. And currently there's an exemption of $12+ million where you're not going to be subject to an estate tax or gift tax for transfers during life and at death if you have an overall estate less than $12 million. And if you're married, there's a few things you can do to essentially, double that exemption to 24 million by passing assets on to your spouse. But you don't need to have that level of assets in order to need an estate plan. Because as I mentioned, things like naming guardians for your children, having a plan dealing with your own medical issues if something were to happen, as well as dealing with your property overall and how you'd like to have that transferred to your heirs. Now, when you talk about transferring assets, people typically think of a will, because historically, a will has been the cornerstone of an estate plan. And the will, you've seen them all read in the movies. They essentially direct who gets what, but they can do a lot more than that. As I've already alluded to, they're the vehicle for naming a guardian for any minor children. So individuals who, maybe are just starting out, have certain level of assets, may not think they need an estate plan, but they have minor children, they may just want to create a will just so that they can appoint that guardian. Likewise, the will can appoint or will appoint an executor. So that's the person who oversees essentially the administration of your estate. And that's something that if you don't pick that executor through a will, then the state you live in or where your property is located, or probably both, is going to dictate who is that administrator. So If you have a will, you can name an executor to administer your estate. If you don't, the court is going to pick someone, they call it an administrator, to manage your estate. Now, a will can also appoint where certain property goes. It can have property go to charity. It can have it go to a trust for the benefit of your spouse. It can do all of these moves that may save taxes, particularly estate and gift or transfer taxes down the road. And that can be accomplished through provisions in a will that essentially point which assets should go in which direction. Now, a will is something that, generally that's something that has to be put in writing and signed by you and witnessed. That's something typically, an attorney is going to create that. That's called a statutory will. It's totally dependent upon state law, whether or not a will is going to be valid in a particular state. There are things such as holographic wills where you can handwrite a will and sign and date it. That might be approved by the state. You can have what's known as a non-cupative will, where essentially you make a dying declaration about certain property, where you want it to go, and you have a number of witnesses who watch that. That might work. But the fact that I'm using the term might, that's really not a good way to plan as well. It might work if I handwrite this will. It might work if I tell people on my deathbed I want who to get which car. But the best thing to do is go through the process, have a will in writing, signed by witnesses, following the state law, drafted by an attorney. The last thing I did want to mention, if you don't have a will and it goes through the probate process, the people who decide where your assets go is not going to be you. It's going to be whatever the legislature of your particular state decided either recently or perhaps decades ago. Because a will is something that dictates where your assets go. If you don't have a will, you're deemed to have died what's called intestate, and the assets will pass according to state law. And typically, that's not going to include any charitable beneficiaries. It's not going to include any relatives who aren't, lineal descendants of yours. So to the extent you want assets to go where you want them to go, and it's not directly to your heirs in the proportion that Wisconsin or Arizona has dictated, that's a reason to have a will. And the way a will is actually proven to be correct and true and valid is through something known as the probate process. And wills are typically filed with the probate court. There are some exemptions in certain states depending upon the level of assets that pass through a will. Some states have maybe a $50,000 exemption or a $100,000 exemption, meaning if you only have that level of assets or less passing through the will, passing through probate, that's the only time you have to actually file with the court. And once you file with the court, that executor is really subject to reporting back to the court, how things are going, how is the estate being administered. And that executor, if you named an executor in the will, they're the ones who are going to be collecting assets, notifying creditors that someone has died and that there's claims to be made against the estate. That also notifies potential beneficiaries who may be kind of lingering in the woodwork for them to come out. But the executor essentially is the one who, collects the assets, pays any debts, accounts for any type of tax returns, and ultimately distributes process or property to the heirs. And this is a process that can last several months. It can last a year. I'm sure you've seen some estates in the news that can last for a number of years. So it is a process, but it only really applies to those assets that are passing under the will. And as we'll see in a second, there's a few ways to avoid having your assets go through this probate process. One, as you may guess, is to have a trust. So some of the pros and cons of probate, because I've kind of painted this draconian picture of having to go to court and account for every move that the executor makes. Well, that may be a con, is that yes, this is a court supervised process, but that's also a pro. If you're a creditor or a beneficiary, the fact that this is a court supervised process means, yeah, it's going to be pretty clear what type of title you're going to get once you get these assets out of the probate process. It's also something that protects creditors because they have the opportunity to be heard, but it is something that does take some time and money. So I always point out that probate is something that takes time, money, but it also does not provide privacy. So you might have seen situations, for example, there's some recently, I'll use one from a few years ago, like the headlines say, Burt Reynolds did not provide for his son in his will. And the reason you could see that headline is because people could look up the probate court records and see, yes, his will did not, provide anything for his son. Of course, it didn't mention that Burt Reynolds had set up a trust for his son, but the fact that this is out there is one of the reasons you may want to avoid probate. And one of the ways of avoiding probate is something known as a living trust. So this is something, it's a trust that's set up, again, it's an instruction book for those who are here after you've gone or if you become incapacitated, which tells them how you want those assets to pass. And it's something that can be as versatile as state law allows. So however you feel your assets should pass, that's how you can do it, provided it doesn't violate some public policy. Now, there might be some tax consequences depending upon how you do it. But again, a trust is really just you, not there. It's really an instruction book for someone else to act at the highest fiduciary capacity to fulfill your wishes. It can also account, unlike a will, which assets might pass out immediately to their beneficiaries once that process is done. With a trust, it's possible to keep those assets in trust for potentially a number of years, and the access to beneficiaries may be limited, again, depending upon the circumstances. But in order for this revocable trust to avoid probate, essentially you create a trust, it has all the terms you like, you name yourself as the trustee, which we'll get to in a second. You also maintain the ability to amend or revoke that trust, but most importantly, you then title your assets in the name of the trust. So it's going to be, Joe Schmo or Jane Schmo as the trustee of the Jane or Joe Schmo revocable trust. You still have total control. It's still your assets, but by actually titling those assets in the name of the trust, they will no longer be subject to that probate process at the time that you die. So in order to avoid probate with this living trust, you have to make sure you actually title the assets in the name of the trust. Now, I mentioned that's a revocable trust where you maintain, essentially control. Any tax consequences still flow to you when you're the trustee of your own revocable trust. It's something you can change at any point, up until you die or become incapacitated, unable to legally change it. But up until that time, once you've created that, you know that it's there. It's that standby tool to give beneficiaries and heirs directions as to your assets and how they'll be treated. Now, there's also irrevocable trusts where you place assets into trust and irrevocably essentially give up control of those. And oftentimes that's done more for tax planning purposes, maybe for some purposes of helping beneficiaries with future creditors, but it is something that is a different story and primarily done for, as I said, tax planning purposes. So just the last couple slides here till I hand it over to Mark. Just this is kind of Trust 101. So the grantor transfers property to the trustee, in the trustee's name, pursuant to this trust document, which contains all the instructions as to how these assets should be handled. While the trustee and grantor are the same person, in many cases with revocable trusts, once that grantor dies, that trust becomes irrevocable and the trust provisions, kick in. And typically you're going to have both current beneficiaries as well as remainder beneficiaries, meaning there are beneficiaries who may be entitled to income from the trust, but ultimately when their term, their share of the trust life goes away, the assets then go to a remainder beneficiary. And it's important to know that state law and the trust document will dictate, okay, what type of income goes out to trust beneficiaries, because each state has its own Principal and Income Act, which the trustee has to understand how that actually impacts, along with the trust document itself, what current beneficiaries should get from the trust. So that trustee, as I mentioned before, they're acting in this fiduciary capacity. Essentially, they're acting in the best interest of those beneficiaries. It's the highest standard of care. that you can have, legally. They're responsible for managing the assets. They're responsible for understanding the trust, understanding state law, including that principal and income. And they're also responsible for understanding the family relationships and what's going on. Because again, to act in the best interest of the beneficiaries, you need to know those three things: how to manage assets, trust law and what the trust document itself says, as well as what's going on with the family and the beneficiaries. And I know Mark is going to reference a little, the business model that we have with Baird Trust, where it's a combination of the financial advisors as well as the individuals within Baird Trust to make sure that we cover those responsibilities. So just a kind of quick wrap up the benefits of using trust. Besides avoiding probate, assuming it's been funded during life, meaning we've titled assets into the name of the trust, there's also the ability to avoid that ancillary probate where you own assets in other states. To the extent the trust is the named owner of that property in various states, there's not going to be any probate that's required in that state as well. So for vacation homes, certain investments, things like that. If you become incapacitated, the trust will kick in and have a successor trustee come in and manage your affairs. For future beneficiaries, the trust can be set up so that creditors cannot get at those trust assets while those beneficiaries are benefiting from the trust. Related to that, it's preserving the assets for the heirs. You can dictate who does and doesn't get assets, similar to what you can do in a will if you make such provisions, but doing this through a trust provides those other benefits as well. And lastly, it's something that if you have, special needs beneficiaries, it's a way to provide for those heirs while still protecting their benefits. The trustee can understand, okay, what's required to make sure that these assets don't impact other benefits that this disabled person may be entitled to. Again, assuming it's been properly drafted at the beginning. So I mentioned planning for incapacity. My first bullet point was this: estate planning is not just if you're dead or dying, and trusts are not just if you're dead or dying. In many cases, having a trust just for purposes of planning for your incapacity is reason enough to do it. If you don't have trust in place and you become incapacitated, it may be that a guardian is appointed, and that guardian is not going to have any instruction book other than what state law provides. So they're not really going to know how you would want your affairs to be managed. And with incapacity, there's a few different ways you can deal with your assets to make sure that if you do become incapacitated, things will continue. There'll be some continuity for your heirs, even for yourself, because these are your assets. They're designed to protect you if you become incapacitated. So one fairly common is joint ownership. So many people will own real estate, even personal residences as joint tenants with rights of survivorship. If something happens to one joint tenant, that other person still has the ability to manage the property. You can also give individuals a durable power of attorney, meaning that they can act on your behalf for your financial affairs. It could be either very broad or very specific. You can have that power of attorney, you set it up today, but it's not going to spring into life unless something happens to you, you become incapacitated. That's called a springing power of attorney. Durable means it just survives your incapacity. And then lastly, as I've already mentioned, a living trust can be set up where, again, you're acting as your own trustee, but you name a successor to step in if you're no longer able to serve. There's some other issues related to incapacity that are kind of outside of a trust. This gets back to why should you do an estate plan? Again, if something happens and you're unable to make medical decisions for yourself, there's a couple different ways you can handle it. One is you can give someone a power of attorney over your health care, where essentially they make decisions on your behalf. So assume you're going to be careful picking someone, you discuss with them kind of how you feel about treatment and extraordinary measures, et cetera. You can also contrast that, or in addition, have a living will, which really spells out in advance, what you would like to happen in the event that there is some medical emergency and decisions have to be made. So one, the power of attorney puts it into someone else's hands. The other, living will, gives a set of instructions of how you'd like to be treated. I'm using very broad terms here because this is very dependent on state law. And, I know attorneys like to be creative, but this is one case where it may be best to use the form that's used most often in that state, because you want caregivers, people at the hospital, to be familiar with the documents that they see that give someone else the ability to manage your care. So I think I already covered these things about the benefits of using trusts. Essentially, going forward, after the trust has kicked in, which, usually when someone has, left this mortal coil, you can have provisions in the trust that provide for beneficiaries, could be for generations, and you can have provisions, again, relating to special needs and also relating to creditor protection if you're worried about, your beneficiaries, either being preyed upon by what you might call people wanting to take advantage, or whether they have their own propensity to potentially overspend. And again, this is something that may be very important depending upon the circumstances. So I'm not going to go through all of these trust terms, just want to recognize that there's a number of trusts that are designed, really for estate planning and even estate tax purposes. Living trust, as I mentioned, is very common. People set up their own trust primarily to avoid probate. Spendthrift just means we want to protect beneficiaries from themselves and have a provision that doesn't allow creditors to get access to these assets in advance. But things such as credit shelter trusts, marital trusts, ILITs, crummy trusts, dynasty trusts, there's SCLATs, there's GRATs, there's CUPERTs, there's CRTs, there's CLTs, there's all types of trusts that can be set up to essentially fulfill your wishes, but do it potentially in the most tax efficient manner while also benefiting your heirs. So I know that's a lot to kind of get in less than a half hour as an introduction, but hopefully this will spell out the importance of having a trust, and understanding the importance of the trustee and some of the duties that they have. So with that, I would ask Corbin if you can hand it back over to Mark, and he'll go through a few examples of some common uses of trusts.
Thanks, Mark, and I really appreciate that. I appreciate you laying out the basics of what a trust is in a probate process. And what I want to take from there is giving specific examples as to why you would use a trust. And everyday life situations I want to kind of merge into our presentation. Why would you use a trust? Now that you know what a trust is, many of you knew what a trust was, but I think Mark gave you more of a breakdown as to how they work in relation to a probate process, and reasons why you would need to use a trust for protection, for example. My piece, I want to go into examples. First, why we would use a trust. For example, using a trust as an IRA beneficiary. Business succession plans, how a trust would fit into that. Transfer of digital assets, and we'll get into what a digital asset is. And of course, charitable giving and how that can benefit an estate, it can benefit an individual. Certainly, it can be part of an overall estate plan. So we'll start with IRAs. And there's been a lot of talk about that here at Baird, everywhere, because of the Secure Act, and we'll get into that in just a moment. There are a lot of changes taking place with how a trust can be an IRA beneficiary and what rules apply. In the past, you can make a trust an IRA beneficiary, use the oldest beneficiary as the expected life, and it can be stretched out over the course of their lifetime and what would be perceived as their likely lifespan. Well, that's no longer the case, and I'll get into that in just a moment. But this can be a big part of your estate plan. And one thing I will say initially is you're going to get a lot of people with a lot of different theories as to why you would use your trust as an IRA beneficiary. One thing I can tell you is that it's always a good idea to have other trust assets in that trust, not just the proceeds from an IRA. There should be other cash, other sources of revenue in that trust. And we'll get into that in a moment. One other reason why it's a good idea to have, well, it can be a good idea to have a trust as an IRA beneficiary is that it affords the beneficiary of that trust more protections, as opposed to the payments going directly to that individual from the IRA. Get into the next slide here. Okay, I'm gonna make sure the slide's there. Trusts are typically going to be taxed aggressively. Okay, and that's why it's hugely important to have your attorney to have a good conversation as to what your objectives are and make sure the proper language is put in the trust in regard to how the payouts are going to go to the beneficiaries, who the beneficiaries of the trust are, what their relationship is to the IRA owner. Those are all very, very important factors, and it's going to weigh in as to how the attorney is going to draft that trust. This in light of the Secure Act. Obviously, that's every attorney that's drafting these types of documents has to take this into consideration. And this SECURE stands for Setting Every Community Up for Retirement Enhancement. This was passed in 2019. There is currently a 2.0 version of this act before Senate. The modified version was passed earlier this year in the House. We're waiting to see what happens with the Senate. As you see on the third bullet point there, the Secure Act pushed the RMDs to be paid out to the beneficiaries from 70.5 to 72. Well, this very likely could be bumped up to 75, depending on whether this 2.0 language is adopted. So there are a lot of changes here, and there's some additional nuances here. One thing you have to always consider when you are naming beneficiaries in a trust, and part of your trust is going to be proceeds from an IRA. It's really important to think about what type of trust you're putting this into and who is going to be the beneficiaries of this trust. You're going to have two different types of trusts that your attorney is going to do an analysis to determine what type of document this is going into, whether it be a conduit trust, and you see the requirements for a conduit trust, as well as a discretionary trust. Conduit is also known as a see-through trust, and a see-through trust has specific requirements in order to be deemed as such. As part of the beneficiaries named under a trust, you're going to have a designated beneficiary, what is considered to be a non-designated beneficiary, and an eligible designated beneficiary. And let's focus on that eligible designated beneficiary, because that's key. If the beneficiary under a trust is determined to be an eligible designated beneficiary, then that means that 10-year period that the Secure Act has put into place, meaning that all proceeds from that IRA have to be paid out to all of the beneficiaries within 10 years of the date of death of the owner. This supersedes that. If you got a surviving spouse, if you got a minor child, you got a disabled or chronically ill individual. And keep in mind, when we say chronically ill or disabled, they have to be deemed as such as of the date of death of the IRA owner, not at a later date. And then you've got someone who is 10 years younger than the original IRA owner. Again, going back to that original IRA owner's date of death. If you've got a beneficiary that fits into one of these categories, then they can have their distributions made out to them over the course of their lifetime based on their expected lifetime. And that's been changed also in terms of designating or looking at someone's age, looking at their situation, and determining what their lifespan may be. These are some of the issues that you may want to consider and why it may be beneficial to you to name an IRA as a trust as a beneficiary of an IRA. It could be a blended family. There could be concerns about your spouse. There could be potential credit protection issues. It could be plans that involve the use of charitable trusts. Planning to help or avoid minimize estate taxes is a big part of this as well. These are all, part of this presentation is for us to get you guys to think about some of these things so that when you meet with an estate planner, the attorney who may have drafted your trusts or your wills, or potentially meeting with an attorney to have this discussion, These are talking points that you might want to think about to help them understand exactly what your objective is. And then we come to business succession and transition planning. And I have some experience with this. Part of my practice was in Minnesota years ago. And I had a number of situations where we had mom and pop businesses that over time had grown. But the structure of it, the succession plan was all based on it still being a mom and pop business. And that's something that a lot of people just fail to address because it started off small, everything's going fine, but in reality, the founder of the business is the driving source here. So as he ages, or she gets to a point where she can no longer run the business, or they pass, or they become incapacitated, then you've got the business itself and the principles of that business scrambling to try to figure out, okay, what type of plan are we going to put in place? Never mind the fact that the objectives and the overall plan, at that point, you're just trying to make sure that there is a plan in place. So before you even get to that point and recognizing that your business is growing and that it's not a mom and pop business anymore, it's good to start having these discussions. It can lead to peace of mind. It's a general path to retirement for the founder of the business. And it gives the founder greater control over where that business is going. These are some of the reasons why, as I discussed a moment ago, why you, in a number of situations, you don't have the proper planning in place because it is emotional. Most people don't want to think about their own demise, okay? And the business is running fine, there aren't any problems. This is a very difficult discussion to have. So sometimes it's just based on emotion. It's not any real barriers there, it's just based on emotion. It is a time-consuming process, and you may have a very labor-intensive business. So when are you going to have the time to get the principles of the business together to really start to discuss, okay, what's going to happen when we have the next generation of leadership here? And how are we going to get to that point? That takes time. That doesn't always involve an attorney initially. It involves the principles of the business determining where they want the business to go. It can be complex. There are a lot of things to consider. There are tax factors to consider. There are family members to consider, new employees, the general growth of the business, whether or not the business may be acquired by another larger business. All these different things come into play, and they at times can be a barrier to actually getting things done and actually having those conversations. You have to start thinking, how long do you want to be in the business? Is this business going to be positioned to be acquired by another business? So again, what is the objective? Where is this going? Does this business stay within the family? What's going to be the structure going forward? Is it going to stay as it is now? Do the principles of the business take the opportunity to make the changes now that the business has grown? It's been around 40, 50 years. The structure's never really changed. This is a golden opportunity to make those changes and at the same time provide a smooth transition to the next generation. This takes time. I had situations in the past where it may have taken longer than that, longer than 3 years, to put together an effective plan because it was done in stages. It was done, again, just the preparation, identifying the issues and the changes that potentially are going to be made, determining whether a trust is going to be a part of this transition. Does it make sense? The way the company is incorporated, does that make sense? Do all of the principals involved here agree as to how this is going to move forward? And if so, you get to a point where everyone can agree this is how we're going to move forward, then it's about the implementation of such. Who do you bring in? Is it just counsel? Is it a tax planner? A business consultant? All these different things. And that transition process takes time. And as I mentioned earlier, some of this becomes cost prohibitive. These people aren't doing this for free. So that's another barrier in people sitting down and really making time to effectively put together a business succession plan. One thing I'll wrap up with that is if that is done effectively over that time period, or it could be much shorter because you're talking all different sizes of businesses. If you can do that, then the overall objective as to what the founder envisioned for that business going forward can be accomplished. I've also seen it where nothing was planned. The person dies, the second in charge may not be around or have a very, very different vision as to what the founder had. And then you've got disarray. You've got day-to-day business operations to be concerned about. And now you're concerned about who is going to be leading this organization going forward. So those are just a few things to think about. When it comes to philanthropic and charitable giving, this certainly can be a big part of anyone's estate plan if they have philanthropic goals. Doesn't mean you have to be a multimillionaire. Doesn't mean you have to give huge sums of money. Certainly there are tax advantages involved, but at the same time, there are individuals who simply want to give to their favorite charity, favorite cause, favorite entity, whatever that might be. Putting together a private foundation certainly does help centralize this, because if you're talking smaller gifts and if you're talking a smaller estate, then you may have an individual who may be able to do that on their own. But as the stakes get higher, as you're talking larger sums, as you're talking a larger estate, then you're going to want a centralized collection of these grant requests. You're going to want to verifications. You want to bring other professionals in to assist with this, putting together a foundation. You see it a lot with celebrities, with athletes, and for those individuals that are high profile, the foundation serves a second cause. It's good PR. It's good PR for those individuals to put that together, whether or not they have philanthropic goals or not. But for the average individual, it usually comes from a place of giving. And these are the steps that certainly help accomplish that. As Mark mentioned, there are a number of different types of trusts. One thing I'm going to take a look at here are the charitable remainder trust and the charitable lead trusts. Both of these will accomplish the goal of paying out to charities, and at the end of that person's life, going to their family members or designated beneficiaries. The charitable trust, charitable remainder trust, will also provide an income stream to the donor during his lifetime. It's important here that you want to be able to control the amount that you are distributing out to these charitable organizations, foundations, whatever the case may be, and also be able to control, after you've passed, to be able to control whatever remaining proceeds are in these trusts. Then they can go to whomever you designate, whether it's your family, your kids, another entity, whatever the case may be. And as far as sitting on a board of a nonprofit, and then let's say it's a big nonprofit, let's say it's a national organization, so it involves a lot. It's not just being a board member in name only. You actually have things and tasks that you have to accomplish. Well, certainly you can use a professional fiduciary to help you in that regard, and some of the bullet points you see there at the bottom. There are a number of things that can be taken off your plate. And it certainly can be helpful and a very, very good use of time. When I started practicing, and I don't want to date myself, but digital assets wasn't a term when it came to estate planning. Certainly we had digital assets back then, but it wasn't referred to as such. The internet was still in its infancy. I know I'm dating myself, but the issues that we're going to talk about here simply did not exist. So what we've seen in recent years is that the law had to catch up, because a lot of these things most people don't even consider. So let's start off by defining what exactly is a digital asset, because we all have digital assets, whether we realize it or not. Whether it be photos, videos, emails, contact lists, etc. As far as your personal digital assets, and obviously with social digital assets, which is, again, that's a phenomenon over the past 15 to 20 years. Okay, so in some jurisdictions, they've been slow to catch up as to these are real revenue generating assets for some people. Other people, it's a novelty. They have a page, they enjoy perusing Facebook, Twitter, LinkedIn, whatever the case may be, but they're not generating any revenue. But for some people, it is a huge revenue generator. So it's a lot of things to think about. You got your financial digital assets, which is your bank account and cards. A lot of us bank online now, bank on our phones. That's a lot to think about when you think about the way we had conducted business in the past, where you're paying bills through PayPal or Apple Pay. And then you have your business digital assets, and I'll get a little bit to more of that in a moment. But with business digital assets, you're talking about business-oriented social media, your company that has a website, your customer and vendor information and intellectual property. I'm going to come back to business digital assets at the end because that's pretty significant as well, and a couple things that most of us don't actually think about. Again, those are some of the things that you should consider. If you're banking online, you've got to have some type of list or documentation of those institutions and accounts. I've been involved in a few estate settlement procedures in the past where we were finding assets at a later date, maybe 6 months after death. We were finding additional bank accounts found in a closet in a box somewhere where there was a list of things that had nowhere close to any of their testamentary documents. We just found it. And sure enough, there was monies in his accounts. Sometimes people forget about it. They may have opened an account years ago and just didn't really think about it, or they become ill and they don't really discuss it with family members, so no one knows. Email accounts. If you have an email account, obviously Yahoo and Google own that ISP, so that expires at death. So if someone's trying to get access to it, a brother, a mother, a father, spouse, they're not going to be able to without some proof of authority. There was case law in Michigan in 2005, and as I mentioned, this is where the law started catching up with our new digital world, and that there was a Marine who was killed in Iraq, and his family was not able to access his email account. They actually went to court, and it created precedent where they had to, Yahoo actually had to turn over the emails that the family had requested. That led to statutory laws being put into place, where you're putting requirements as to an estate, trust administration, and who has the authority to be able to call those assets on behalf of the deceased person. And again, at the bottom, email addresses should not serve as usernames or portals for access. I've seen that before. That's definitely not a good idea. Coming back to this, as I mentioned earlier, a lot of us, in this world we live in now, you'll have your files in your work computer. You may have some personal documents on there. It happens. You may have saved something. Perhaps you didn't want to send a document from your phone, so you send it from your work address. That happens. Okay. But what happens when you die and you've got some sensitive information on there and your family member would like to gain access to it? Well, that's going to be a problem because obviously a work email could have proprietary information that unfortunately the company may not be willing to share in order to turn over the emails of the deceased person. So that's something to think about, where your digital information lies, and always think, who's going to have access to this if I'm not here? Because quite often you're the only person who knows that it's there. You haven't told anybody because it seems insignificant. But if you haven't shared it with someone, it's trapped. And that's obviously going to create a problem. Now, in 2014, the Uniform Fiduciary Access to Digital Assets Act went into effect. This was put together by the Uniform Law Commission. This was codified in many states since then. We have, and the next slide will talk about the Arizona statute. This provides some guidance. Okay, this gives you something that you're basing your search or your right to access these documents and the requirements for a fiduciary to be able to present to access digital assets of a deceased person. In Arizona, that is Title 14, 13, 112. There are forms out there. I don't know if they're in all the states, but certainly we have it here in Arizona, where it's basically a consent form that a fiduciary can use in order to present to a Facebook, to a LinkedIn, to any of these entities to show their authority and allow them to direct that a page should be shut down, direct where payments for revenue generating page, where those revenues are going to go, whether that relationship is going to continue. It gives the fiduciary the authority to be able to make that call. This is something, as I mentioned at the top, these are things that we just didn't consider 25 years ago, that we really didn't give a whole lot of thought to. And I can even tell you 10 to 15 years ago, as it was becoming an issue, attorneys meeting with clients to set up an estate plan quite often weren't having this discussion. If there's nothing else you take away from this portion of today's presentation, if you have a will, if you have a trust, so you've got your testamentary documents in place, make sure there is a list attached to those documents where you're listing your digital assets. That document shouldn't necessarily be laying around the house or just anywhere. It should be considered part of your testamentary plan, whether it's referenced in your trust document, which is the best to have a trust document that is referencing a separate document that's going to list account numbers and the types of digital assets that you have, passwords, and the like. It's good to have that with your testamentary documents. You're making life a lot easier for your trustee of your trust, for the personal representative of your will, to have all of those documents in place as they go about the business of collecting your assets. That gives them a really big stick to fight with. They're not going to run into the wall that so many people run into. And these authorization forms, that's good to have part of your plan too, so that your fiduciary, your trustee will have that document. They've been given the authority to present to any third party that they have the authority, short of a probate process going on, because quite often, in order to do these sorts of things, if there's a probate process going on, then there is a document that the personal representative is going to have and present to any third party. It's called letters testamentary, and that document will allow a personal representative to access bank accounts, make decisions on behalf of the estate. The trustee could have a certification of trust document, but that's not always going to rule the day. So making sure that you have a list put together along with your testamentary documents, and keep in mind, that's a fluid list. That's always ever changing. You acquire new digital assets on a weekly basis, probably for a lot of us, whether it's changing of a password, whether it's signing up for loyalty points, whatever the case may be, we're constantly accumulating them. And we don't really realize it as we're accumulating them until you have a third party, such as a trustee or a personal representative, trying to go through your estate and understanding that your estate is comprised of assets that are more than just tangible assets. So that leaves us to where you would start the administration process here at Baird. The information we're giving you as far as considering a trust, considering naming a successor trustee of your existing trust, does not have to be Baird Trust. This is for your informational purposes. Certainly, we do offer these services, and it's important for us that you are aware of it. Questions you have, you can take to your financial advisor here at Baird. They then can bring in myself as a trust strategist, Mark as a trust strategist, our estate planners, and start to determine what's going to work best for you. Taking a look at your existing documents and determining whether or not a trust with us acting as successor trustee or naming a corporate successor trustee makes sense. Reviewing the trust language, the types of assets held by the trust, as we mentioned earlier, if an IRA is involved, if you've got digital assets, and that's a separate list attached to the trust and other testamentary documents, whether this is going to be a new relationship in terms of having a trust or whether this is an existing relationship. Those are all going to be factors as to whether or not Baird would be involved potentially, or any corporate trustee as a successor trustee. This slide gives you an idea of the business model we have in place. As you see, the financial advisor is kind of the engine there, and you see all the other players as needed can be involved. If you need an estate planner, if you need a portfolio manager, trust officer is going to be the person initially driving the engine throughout this entire process. But this is going to fluctuate depending on your situation and depending on your individual needs. There are a lot of players involved, as I mentioned, depending on the complexity and size of your estate. If you're looking at bringing in an attorney, a financial advisor, CPA, insurance professional, those are all parties that we have here at Baird. And that certainly, if we don't, we certainly can refer you out to individuals who can help in that regard. I'm running short on time, so I just want to finish the last slide here. But in order to get started, and your financial advisor, again, can review some of this with you, in order for us to begin our process here, we would need to take a look at your financial asset statements to generally understand the size of your estate, complexity, and the type of assets that you hold. Information on any other trust assets. If you're named as a beneficiary in a trust, we would want to take a look at that to see what the terms of that distribution to you in the future would be. Obviously, copies of your existing trust documents, any amendments, restatements, wills, codicils to the wills, and any other relevant agreements. And also a good discussion regarding your family dynamic, if you have a family tree, so we understand the nature of your family, whether it's a blended family, whether it's a traditional family, and obviously the dynamic of said family. That's all I have for today, and I'm going to turn it back over to Justine.
Great. Thank you so much, Mark Criner, Mark McLennan. We really do appreciate it. We've had a ton of questions come in, and I know we are getting close to time. But just as a reminder, if you'd like to ask a question, you can feel free to do so by clicking that Q&A icon on the bottom right-hand side of your screen. We'll try to get through as many as we can in the short amount of time that we have left. So with that, Mark and Mark, I'm going to throw a few out to you. First question that came in, is the trustee typically an attorney, or is it usually one of the beneficiaries?
That all depends. Certainly it can be an attorney. Obviously, I'm biased. In my opinion, best case scenario, it would be an attorney because they're going to have a better understanding of this entire process. Certainly, it can be an individual or family member. One thing to consider, if you are naming a party and you're in your 50s and it's 20 years later, now you're in your 70s, you might want to start thinking about naming another successor trustee because that person is getting older as well, and it may be a complex process that you're not equipped to deal with.
Great, thank you. Along those same lines, if I designate my children as co-successor trustees, are they also considered beneficiaries?
I can answer that one. Beneficiary and trustee are totally different terms. The trustee is the one who's responsible for managing the trust assets and has that fiduciary responsibility. They have legal title to all the assets. The beneficiaries are the ones who have the equitable title to the assets, meaning they're the ones who benefit from the trust. Now, in many cases, you might have the same person be a trustee and a beneficiary, but if you're doing that, depending upon your goals, in many cases, you don't want someone to be a trustee over a trust where they're also beneficiary and they have like total control. If you're trying to set up a trust to protect beneficiaries from creditors, but the creditors can see, well, that same person is trustee, they might be able to pierce through that and say, well, we should be able to get access to that. So there's also estate planning reasons why you may or may not have somebody be a trustee as well as a beneficiary. But kind of related to the previous question, oftentimes you might have a family member be co-trustee along with a professional trustee, whether it's a trust company like Baird Trust or an attorney. And that trustee who's a family member may have some say in some kind of discretionary distributions where the other trustee is responsible for asset management and principal and income accounting and that type of thing, but they do get some input directly from a co-trustee family member.
Great, thank you. Next one is, how often would you recommend a trust to be reviewed? Is there a specific timeline, or is it more around like life events like death, birth? What would you suggest?
I would say both. Life events certainly would dictate the necessity for having a review. I would say every 2 to 3 years, to be quite honest, because of all the changes in the tax laws that we see. And again, changing life circumstances, kids becoming, reaching age of majority. There are a number of reasons why you want a review of a document that's no longer effective because 20 years has passed and you're in a different place in life.
Yeah, I would say the same thing. Life events, tax law changes, and life events can include the fact that you're a different person now than a few years ago. Even if family members haven't changed or relationships, your assets may have changed, and you want to look and see, okay, does this still accomplish what I need to accomplish based on the new set of facts.
Great, thank you both. And I know we are at time, so I do apologize. But for any questions that we were unable to answer today, I just recommend that you reach out to your Baird financial advisor and they will loop in any appropriate resources for you guys to get in contact with. So we encourage you to continue that conversation with them. As a reminder, for those of you who'd like to review today's presentation or share it with a friend, family member, colleague, the session has been recorded and will be made available in approximately a week through your Baird financial advisor or via bairdwealth.com under the Insights and Education tab. So with that, thank you, Mark and Mark, for your time today, and thank you to all of our clients on the line today. Have a great afternoon.
Thank you.